Settled in. We'll get started in just a minute. All right, so we are about to get started. Before I introduce our next speaker, just a reminder to any teachers who are attending virtually to include either your name or your email address in the comments so that we can make sure that we get you your credit for attending. If you are having any difficulties with making comments or putting anything in the chat, feel free to either email myself or Kathleen Pate and just letting us know that you are in attendance, and we'll do it that way as well. So welcome back for our noon program. We're very excited to have you. We're very excited for our next speaker. We are pleased to welcome Mr. Jeffrey Jackson, who is the Dean of the College of Law at Washburn University. So please welcome Mr. Jackson, and we look forward to your questions after his presentation.
Thanks, everybody. So I'm here today to talk about the Brown case from a legal perspective and to talk about what made the arguments in Brown sort of unique. And so I'm going to do this with a little bit of a PowerPoint and picture. I guess the first thing I want to talk about is what about Washburn and Brown? And that's kind of what my first slide's going to tell you about, because Washburn University has a pretty big history with the Brown case and Brown versus Board of Education. One of the things that we're very proud of is, of course, Washburn was founded as a university by ex-abolitionists who wanted to have a university that was open to all races and gender. And so one of the interesting things that came out about that is, of course, we were graduating African-American students. We were graduating women long as attorneys, a lot of other places. And so the Brown case was actually filed by 3 Washburn graduates, John Scott, Charles Scott, and Charles Bledsoe, who worked for their father, Elisha Scott's law office. As I say, they were all Washburn graduates, and we're incredibly proud of that. Of course, as I feel compelled to say, we also had the entire other side too, because we had Lester Goodell, who was the main attorney for the Board of Education in Topeka. And then when the case went beyond that, Harold Totzer was the attorney general for the state of Kansas, and Paul Wilson was the one, and we'll talk about how they got involved in the case. Paul Wilson was the one who actually argued it on behalf of Kansas in the Supreme Court. And in the district court case, we also had one of the judges, Judge Delmas Hill, was also one of our graduates. So we were pretty well on both sides. But one of the interesting things about it, I think, is that it illustrates kind of the reason that the Brown case was so interesting, because the fight in Kansas was not between, I guess, ardent segregationalists who for sure wanted Kansas high schools to stay segregated, or Kansas elementary schools rather, to stay segregated. Rather, it was, a much more civil fight that was happening in Kansas, and it's one of the reasons that I'm going to talk about that is the reason that Brown became the case. Because if we look at Lester Goodell, who I said was the main attorney for the school board in the case, he had actually gone to law school with John Scott, who was one of the attorneys for Brown, and he was also a friend of their father's, and he would sometimes go visit their house. So it was one of those things where everyone was, working on just the legal angles of the case, and that made it important. So I guess, but it's important to understand that Brown, even though it gets the headlines, it was not the only case involved, right? There were other cases consolidated with Brown. I want to talk just a little bit about them because they also play a part in figuring out how the legal strategy works for the Brown case. What made the Brown case so ideally suited for this moment in time? So the first case that I want to talk about is Briggs versus Elliott out of South Carolina. And this is the one that, by all rights, if we were going alphabetically as often the Supreme Court does, would have been the headline case. But there are reasons why it is not. It is basically an action where the parents wanted to get transportation to school for their children. That's all they wanted. But the school district did not do that. They provided transportation, but only for the white students. And that meant that if you were an African American and you went to your school, you had to walk 9 miles a day. But that wasn't the other big thing, right? Because the schools themselves, as you'll see on this next slide, were quite different from each other. If you look at this is the all-white school on the end there, and it looks incredibly modern for the 1950s. Whereas the African American school next to it is in fact a tar paper shack. It had no running water, no plumbing, and it had no electricity at all and was lit by kerosene lamps. And the only source of warmth in the wintertime was a wood stove that it had there. So it was definitely not one of those things. So what happened in Briggs, the first case that was filed in the Briggs case was really only attempting to have a situation where they were just wanted to nothing. They weren't even trying to get equalization. But the Board of Education in South Carolina wasn't having any of that. And so what Briggs evolved into, with help from Thurgood Marshall and the NAACP, was an attack for equalization of facilities. And this is really what the NAACP had been doing in a bunch of other cases, not dealing with elementary schools or high schools, but rather simply dealing with colleges, graduate schools. The idea that they started out with was, okay, separate but equal is the law. Well, we're going to hold them to it. And so those cases were filed in an attempt to say, okay, we'll make them truly equal. None of this disparity that we see here. And part of that strategy was, at worst, everything would be equal, but probably the other strategy is that they were talking about is, turns out that if you're going to make all your schools equal, segregation becomes really expensive because you've got to make sure that everything is equivalent all the way through. And so there was this idea that maybe that was the way to get at segregation, was simply to demand equality. And with equality, what you'd end up with is everything equal, is everything is too expensive to maintain separate school systems. So in Briggs, there was really no idea that they were going to challenge it under, challenge segregation itself. They were just going for equality. But as it turned out, the judge that it was assigned to, and this was kind of the first example of that judge forum shopping that we hear going on today. They filed it in a place where they knew the judge it was going to be assigned to, and knew that he was a supporter of the anti-segregation movement. And the judge said, well, why don't you try and attack segregation directly as well? He said, I can't do anything, but maybe it gets up there. Well, as it turns out, while that case was going on, James Byrne was the governor of South Carolina. The important thing to understand about that is he had just concluded his career as a Supreme Court justice. And so he was wise to these legal maneuverings, and his idea was to short circuit the case completely by announcing new taxes that would be used to benefit African American schools. And so his plea to the court was, look, we know the schools are equal. I mean, all you have to do is look, right, to see that the schools are not equal. But they said, we're working on it, because now we have taxes, now we have things that can get some things done. And so you've got to give us time. Just give us a little time. We'll get everything completely equalized. Well, so that was kind of the way that he was hoping to approach this. Briggs is also interesting because it's the first time we saw the expert testimony of Dr. Kenneth Clark, and from the City College of New York. Professor Clark is famous because he is the one that did the doll tests, right? And those are the ones that if you go to the Brown Museum today, you'll see the dolls that they used, with the idea that his famous dolls test would show, from a psychological perspective, that segregation in and of itself was damaging to the African American child and made them feel inferior. Now, the interesting thing about this test is they were really great publicity. They weren't really great psychology at all. That is, they were probably the least scientific valid of tests that you could come up with for this sort of thing. They just weren't of tons of value in that way, but they made for really compelling pictures. They made for compelling pictures in newspapers. They made for a compelling kind of argument. And the doll tests weren't really half of what Kenneth Clark actually did. I mean, he actually presented other psychological testimony as well. But it's the doll test that I think he's justly become famous for. Well, the district court ruled that segregation in and of itself didn't violate the Equal Protection Clause, but they did say, hey, you have to begin equalization, Governor Burns, and you have to begin it immediately. So that was the Briggs case. That was the one that did that. So if you can advance me about 3 slides. The next case that came after Briggs versus Elliott was actually in Virginia, and it was Davis versus the county school board. And again, it was another one of those situations where really what's happening here is equalization more than anything else, because their high school, the African American high school at issue in Prince Edward County, didn't have a gymnasium, didn't have a cafeteria, didn't have an infirmary. There were no restrooms for the teachers, and they had overflow, which they put in an old school bus and some tar paper shacks. So this is one of those situations that, again, looked like it would be ripe for equalization. Well, this is the first time the NAACP tried another strategy. They said, we're not going to go for equalization here. We're just going to use that as our alternative argument. We're just going to go and say, because what we first want to say is, look, segregation in and of itself is not equal. Well, the district court, however, found that segregation doesn't violate the 14th Amendment, saying that we have found no hurt or harm to either race by segregation. And instead, segregation is simply declares one of the ways of life in Virginia. But the court did, as they were wont to do in those kinds of cases, grab the second argument, which is that the facilities were inadequate, and said, well, you have to address them as well. And so what we really see here when we're looking at all these other cases is you've got a situation where you're bringing a case because not only is the argument separate but equal is wrong, but you've got a situation where facilities are completely unequal. And what you see district courts doing are seizing on the inequality and ordering those addressed, but not really addressing the main point of segregation in and of itself being unequal. There were two cases that actually came out of Delaware that got consolidated, and that's the Belton and Beulah cases. And in those cases, again, you were talking about inequality and busing inequality. In those cases, in Delaware, you had the white-only school that was a 4-classroom building, landscaped, auditorium, basketball court, drinking fountains, whereas the school for African-American children was only 1 room, and it could be converted into 2 rooms. They had a slider to do that, but it had no auditorium, of course, no sports facilities of any kind, no drinking fountain, and it had 1 toilet for the school. So, and the toilet wasn't actually a real toilet. It was one of those portable kind of toilet things. So it was one of those situations where, again, there was a way for the court to duck the segregation as illegal idea. And in this case, one of the interesting things, the other interesting thing is they brought it in Delaware Chancery Court. If you don't know what a Chancery Court is, Delaware is one of the few states that actually still has them. The idea of a Chancery Court is the judge in that court, it is a very equity-based court. So the judge in that court is empowered to do a lot of things, whatever it takes to bring equity. And so one of the interesting side effects of these sorts of things is that the chancellor, because they're chancellors in the Chancery Court, they're not judges, they're judges, but they're called chancellors. The chancellor in this case actually left the bench and went and visited both the schools, because you can do that in a Chancery Court. And I think that's a neat thing. What he basically did is made a finding that said state imposed segregation in education is itself denial of equal protection, because it leads to African American students receiving an education substantially inferior. But the problem with filing in a Chancery Court is Chancery Courts can't strike down statutes. And so it was more of an advisory opinion. What he could do is say that the facilities were not equal, and he could order equalization of facilities, and he did that as well. And the other big case, the one that gets its own Supreme Court opinion because it's Bowling versus Sharp, and that's in the DC case. And the reason is All of these cases were filed under the 14th Amendment, which contains an equal protection clause. Well, the 14th Amendment works against states, not the federal government. For the federal government, you have to assert a due process violation, which includes equal protection under the Fifth Amendment. And so both had to be decided there. And in that case, it was really a challenge to segregation itself. But the court was easily able to duck that because there was already a case on the books in DC that said segregation was okay. Which leads us to Brown. So why was Brown the best case to be challenging segregation? Because that's part of the reason Brown got to be the best case. And the first is Topeka, Kansas was a city in the north as opposed to a lot of cities in the south. Now, north barely, but Topeka was a segregated city, but it was sort of a half-hearted segregated city. For example, junior high and high schools were not segregated in Topeka. Only the elementary schools were. And so there also wasn't as I say here, historical baggage that a lot of places had because Kansas had been a free state bastion and Topeka was that. And Topeka had a very weird, of the other segregation that occurred in Topeka. There was one segregated movie theater, there were two, obviously. Segregated movie theaters, one that wasn't. It was just a very inconsistent segregation that Topeka had. The other ideal reason is everyone was able to sidestep all of these questions about were the facilities equal. That is because there's just been a recent overhaul of school buildings. The facilities in the Brown case, both the school that Linda Brown wanted to go to and the school that was the Monroe Street School and the one where the museum is now that she actually ended up going to, if you go visit them, you'd be amazed that they are pretty much exactly equal because Topeka had just overhauled a bunch of its school buildings. In fact, they were designed by the same architect. And so they had all of the same basic amenities. They were about the same size. In fact, the School for African Americans had a fireplace in one of the rooms that the white school did not have. It was added because it was the second school built, and they thought, we have some money to put a fireplace here. And in fact, the qualifications of teachers, because it was so much harder for African Americans to get jobs as teachers, generally those that did had more master's degrees and in some cases a doctorate. So the teachers were actually more educated at the African American school. And so this was a really big thing because it meant that obviously you didn't have that argument to fall back on, then okay, we'll just equalize the schools and everything would be fine. The only way you win in Brown is if the mere fact of segregation itself is unequal. So that was why Brown became the case for what happened. I'd like to say one thing you can say for Topeka, apparently we did segregation well by doing it poorly, inconsistently, and not very well. So basically, the only way you win here in Brown is if segregation itself is not the equal thing. So how do you prove that? How do you prove that segregation is wrong? Somehow a denial of opportunities? Because if you look through all of the different cases that had dealt with segregation up till then, the only time you won was equalization, right? Or showing that you were not getting an equal opportunity. And really, Supreme Court precedent, including Plessy, of course, said separate but equal's fine. So how do you show it? Well, the strategy in Brown was that segregation leads to detrimental effects to African American children. Just by virtue of it being segregation, them not being allowed to mix with white children, harms them psychologically and labels them inferior. It's a labeling thing that inhibits their ability to learn. So what do you do to prove it? How do you get there? Well, to prove the case, the plaintiffs needed to have experts that would be able to testify about this. And it had to be experts in psychological things. Unlike many of the other cases, Brown actually, although the dolls are there, the dolls were never used in the Brown case. Instead, what the plaintiffs did is they brought a whole group of experts in psychology to testify. And it was really one of the cases where they invested heavily in psychological experts. There was Dr. Horace English, who's a professor of child psychology from Ohio State, Dr. Wilbur Brookover, who was from Michigan State, a social psychologist. And so both of those had testified that the effect of segregation was to stamp upon African American children. They weren't as good, not as good as learning. You have to be segregated from your white peers, and that they were a subordinate, inferior kind of citizen. And then one of the other really interesting people that testified was a sociology professor, Dr. Louisa Pinkham. She's from the University of, she was all right. How we doing? Yeah, there we go. So she worked at the Menninger Foundation, and she testified that segregation produces a stamp of inferiority, as she put it, for the court. A stamp of inferiority on the people who are subjected to it. So the case went in the district court before a 3-judge panel, as cases did in those situations where you were actually dealing with finding a statute unconstitutional. And the court, looking at Plessy, said, well, we're bound by Plessy. But I think the interesting thing is the court in Kansas, and most especially, there was a situation where the court itself, you could tell, didn't really feel like they wanted to hold that way. And one of the big things that they did that would help the Brown case when it finally came is they made a factual finding. And that's on the next slide. The district court said, Plessy says this is not a problem, but they did find that segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law, for the policy of separating the races is usually interpreted as denoting the inferiority. A sense of inferiority affects the motivation of a child to learn, and segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and deprive them of some of the benefits they would receive. in a racially integrated school system. The reason this finding of fact is so incredibly important is we're going to see it again. And you know where we're going to see it again? It's the opinion in Brown. So the case goes to the United States Supreme Court from the U.S. District Court under the rules at the time. If you had a 3-judge panel dealing with that, it didn't go to the Court of Appeals. It actually went all the way up to the Supreme Court, where it was consolidated with all of the other cases, including Bowling versus Sharp, even though Bowling versus Sharp gets a second opinion. And the arguments got a little more sophisticated. The plaintiffs had a twofold attack here. First, they argued that if you looked at, right, because now the question is, we know Plessy probably controls this case. How can we say that it doesn't? And so the plan of attack here is, first, what the court has been doing, the most recent decisions in education trended away from segregation. In other words, it's not that the court might not have been right in Plessy. It's just this is a different time now, and the court's decisions are reflecting that, which is sort of true, at least in education by this time, because in all of the ones in colleges and in graduate schools, like McLaren versus Oklahoma and Sweat versus Painter down in Texas, they had found that they needed to equalize it, or there was no way to equalize it. And then second, they basically were seizing on that finding of fact at the district court, along with all the psychological testimony to show that it was inferior. So when it gets to the Supreme Court, or the other side, right, the segregationist side here had some pretty heavy firepower, because the defense for the consolidated cases was led by a person named John W. Davis. John W. Davis was the senior partner at a 150-person law firm in New York City. He was recognized as one of the greatest appellate lawyers in the nation. Now, at the time of Brown, he was 79, but he still went into the office every day and was still incredibly sharp. Further, not only did they have decades of precedence on their side, you're trying to argue that segregation violates the 14th Amendment, but as it turns out, the same Congress that sent the 14th Amendment to the states for ratification also in 1866 had also made appropriations for the segregation of the DC school system. So it's very hard to say, yeah, Congress intended to outlaw segregation if, after they sent the 14th Amendment away to be passed, they approved segregation in the DC school system. So if you're talking about original intent, the original intent is actually probably not great if what you're trying to do is say they were against segregation. There was a problem, though, with the defense, and that had to do with Kansas again, because Kansas was, again, proving kind of wishy-washy on this segregation thing. The Topeka School Board had come to the conclusion that they might as well get rid of segregation. And so they had rushed to do that. And so they were dismantling the very segregation that had led to the Brown case. And they said, we're not going to defend segregation. So we're done with this case, which meant that the Attorney General's office would have to defend it on behalf of the state, because there was a state statute that allowed for segregation, didn't mandate it, but allowed it. But the Attorney General, Harold Fatzer, he didn't want to do that, mainly because there was an election coming up, but also he didn't want to be associated with that. Finally, the Kansas Supreme Court basically had to talk to the Attorney General's office and say, we probably need to defend this statute, so do something. And so the job was given to an assistant Attorney General by the name of Paul Wilson.
who had never argued before the United States Supreme Court. He wrote a book, actually, which is great reading. He wrote a book about his experience called A Time to Lose. He was definitely not a segregationalist, but he did his best to defend the statute because, as he said, I thought that was my duty. He said, I thought segregation was wrong, but my job as an attorney is for the state is to defend the state's statute. So I did that. So at oral argument, the Supreme Court heard the cases, and this is one of those situations we all talk about. People say, well, Thurgood Marshall argued that case clearly in the U.S. Supreme Court, and that's true. He was one of the attorneys that argued the case on behalf of the NAACP. They were actually, the way that they did it is they argued the cases sequentially, even though they basically dealt with the same thing. So you had Robert Carter, who's a famous NAACP attorney, squaring off against Paul Wilson in his first appellate argument. Thurgood Marshall, as the headliner, chief of litigation at the NAACP, got to face John W. Davis before the judges. Spotswood Robinson, another famous attorney for the NAACP, faced Justin Moore, who was of them all a pretty ardent segregationalist. George Hayes, James Nabrett argues against Milton Corman, and Lois Redding argued against the Delaware Attorney General, who was Albert Young. So you had all these cases argued, and it must have been an interesting experience because the oral arguments took 3 days, and it was basically the same argument, just argued by 6 different positions for and against. On his way out the door, John W. Davis was talking to Justin Moore, and he said, I think we got it won, 5-4, maybe 6-3. But that's because John W. Davis was thinking about precedent. And as it turned out, this was wrong. But we didn't know it yet because when the justices met to talk about it, they didn't take a vote right away because they almost never did. What they would do is they went and met to have kind of general ideas. And it looked like they were leaning toward striking down Plessy. That was the flavor of them. There were a few justices who were pretty sure dissents. One of them was the Chief Justice, Fred Vinson. But even among the people who favored striking down segregation, there were a lot of different opinions as to how, why, and then what would you order. And the justices were concerned that doing something as momentous as striking down segregation, if you did it in a decision that came out like so many of the courts today, 5-4 or 7-2, or even if it's 7-2 and you have concurring opinions and some dissenting opinions all together, it would very much weaken the situation. So to give the justices the times to kind of work through the issue and to get on the same page, what the court said is, let's set it for re-argument. So rather than making a decision now, we're going to rehear the case and we're going to ask the parties to address some different questions in greater detail. The first thing they wanted to know, and I've got this on, I think, the next slide. One of the big things they wanted to know is, what does the 14th Amendment say about segregation, right? What is the original idea there? And then second, did they understand that maybe it didn't abolish segregation, but Congress could abolish segregation? And then finally, if segregation was abolished, how would you do it? And what kind of time period would you need for all of this? So this is one of the big things. The other interesting thing about this case is the Supreme Court mandated that the federal government get involved as well. And they asked the brand new Eisenhower administration, who had just come in, what do you think here? Now, we all knew because Eisenhower was committed to the abolition of segregation. That was pretty well known. But the problem is he had just gotten into office. And so there was a question about should that be a step that is taken so quickly? Eventually, the government's brief who was written actually by the Assistant Solicitor General Philip Ellman, took a more measured approach. In answer to the court's request for the history of the 14th Amendment, what the Eisenhower administration said is, well, the 14th Amendment really doesn't say one way or the other on segregation, right? It doesn't say that because when you think about it, at the time of the 14th Amendment, so we're talking 1868, at the time of the 14th Amendment, there really weren't public schools. I mean, there were some, but not very many. And those weren't the kinds of things it was. And so the government said, you need to look at what the 14th Amendment is designed to do. And they said it established the broad constitutional principle of full and complete equality of all persons under the law. And it forbade all legal distinctions based on race and color, right? So basically, the Eisenhower administration's position, and the one they were arguing that the court should accept, is this idea that you look at the 14th Amendment very broadly, right? You look at the 14th Amendment and look at the spirit of it. Don't bother about whether Congress at the time looked at the segregation thing or thought that the 14th Amendment had to do with segregation. Look now, but apply the spirit of the 14th Amendment, which is to make equal what needs to be done. Before the case could be reheard, there was one of those lightning strikes. September 7th, this is 3 months before the new hearing, Chief Justice Fred Vinson dies of a heart attack. After a court session. The interesting thing about this, right? So Vinson was probably a vote against ending segregation, not because he was an ardent segregationalist in any way, shape, or form, but he was a pretty astute politician and thought that the court would get into trouble by doing it, right? So he was a tepid vote for segregation, probably, in the grand scheme. But having him die turned out to be fortuitous for the Brown opinion, in that rather than having a bunch of splintered opinions, Vinson was replaced as Chief Justice by Eisenhower, who tapped the governor of California, Earl Warren, who would go on to be incredibly famous as the Chief Justice of the Supreme Court. And Earl Warren was a for sure vote in favor of ending segregation. This next slide is a quote from Justice Felix Frankfurter, who did not like Fred Vinson at all and did not respect Fred Vinson. And he remarked just before the Brown rehearing that having Vinson die before then is the first indication I have ever had that there is a God. So you can tell they weren't getting, sometimes we think the Supreme Court doesn't get along well now. Welcome to pretty much every era, really. So we get to the re-argument, right? And to be fair, the re-argument was pretty anticlimactic. It was another 3-day hearing, and it featured John W. Davis again. This was the last of his 140 Supreme Court arguments that he did. And by all indications, he was still on the top of his game. But outside of the drama, nothing really moved the justices to change things. Instead, really what got repeated ad nauseum over those days was that the defendants argued that the 14th Amendment was never understood to outlaw segregation. And the plaintiffs arguing that, Well, the 14th Amendment was meant to end discrimination, and segregation is discrimination. There were basically two irreconcilable points of view, both of which are probably correct in that, Congress probably didn't have a thought when they were passing the 14th Amendment that it would apply somehow to segregation of schools, mainly because that wasn't foremost on the mind. But if you look at the spirit of the 14th Amendment, its idea is to end discrimination where it has bad effect. And the argument here is segregation, it might not have been understood to be bad then, but it has a bad effect. So then the justices meet. And luckily, we do know some of the stuff that they talked about. We have not terribly well written notes from many of the justices about the conference and what they were happening. And it was fairly clear at the first meeting they weren't going to take a vote or anything, but they were just setting out their initial things that the votes were there. But again, the opinion looks like it was going to be fractured. Warren, Justice Hugo Black, Justice Frankfurter, Justice William Douglas, and Burton and Sherman Minton were solid votes in favor of ending Plessy. Right, so you've got 5. That's enough right there. Tom Clark, another justice, was also in favor. But what he wanted to do, he said, was let's not talk about what we do. We strike down segregation. We talk about what we do and how we go about it. We'll do that later. And then Justice Robert Jackson, he had just gotten back not terribly long ago he was the prosecutor at Nuremberg. He took time off from the Supreme Court to be the prosecutor at Nuremberg. And he was an interesting person. One of the things he wanted the court to do is he said, look, I'm all for ending segregation, but we can't pretend that we're doing it because the precedent tells us that we have to, right? He said, we might as well say we're doing it because we now think segregation is bad. And I want to be able to say that in the grand scheme. And so he said, I think I'm probably going to write a concurrence doing that if we don't say that. So I'm sure all of the justices on the anti-segregation side were like, oh, great, we're going to get a concurrence out of this too. And that would somehow deny the force of law. In fact, only Justice Stanley Reed of Kentucky was in favor of keeping separate but equal. And he was, to be fair, again, not an ardent segregationalist. He had just grown up with segregation. And he was kind of thinking that it just, as a legal thing, as long as everything is equal, it's got to be okay. So that was the way he was thinking. But then they met. By the time the actual vote came around, sometime in March, it was 8-1, because by this time Justice Jackson had reconsidered his concurring opinion and instead joined the majority. And in fact, part of the reason that he came to this conclusion, because for quite a long time he was still thinking of writing a concurring opinion, he had a heart attack. So it was the second heart attack during the Brown case. And he did not die. He was in pretty good health beforehand, and so survived the heart attack. But he kind of said, well, that would be a lot of trouble. I'll just join the concurrence. So Brown is a case of 2 heart attacks having some influence. So all of a sudden it's 8-1. And then it wasn't anymore because Stanley Reed said, well, you've convinced me. I guess the time really has come to strike down separate but equal. And so Brown became a unanimous opinion. And the interesting thing that you see when you look at the Brown opinion, which was written by Chief Justice Earl Warren, the thing that you see when you see the Brown opinion is the echoes of the earlier cases. The Brown opinion is short, and it hits on basically three major themes. The first is on the history of the 14th Amendment. The court said it's inconclusive with regard to segregation. It doesn't say either way, which is what the Eisenhower administration had been urging the court to adopt, right? It was the argument that the Eisenhower administration had been urging the court to do. The court then reaffirmed the importance of education as perhaps the most important function of state and local governments. And then the court quoted the findings of the Kansas case regarding the psychological damage wrought by segregation and pronounced that this, they quoted the whole thing, and they said this is amply supported by the modern authorities. And then they cited all of those psychological experts who had testified in all of the cases beforehand. And this led the court to its ultimate conclusion, which is that separate educational facilities are inherently unequal, and they violate the 14th Amendment's Equal Protection Clause. A unanimous decision from the Supreme Court. Now, of course, we all know that just having the Supreme Court pronounce didn't completely give victory and didn't make everything equal overnight, but there were going to be a decade basically and more of struggle after Brown before we got to a place where we could say things are much better. But what it did is, in striking down segregation, striking down legally enforced inequality, Brown basically made the end of that kind of discrimination inevitable. So, questions? Any questions you have? Yeah, go ahead. Oh, yeah, the easy thing. It is a positive, actually, but what it is basically saying, I agree with what the court did here, but I don't agree with the reasoning. I write separately so that I can say, here's what I want to, and sometimes it's not, I don't agree with the reasoning. It is, I agree with the reasoning, but I write because I want to emphasize this point, which may or may not be what everybody else thinks. And it would have made it so that, there was not a unified front, and it certainly would have been much weaker than the what eventually became the unanimous decision.
Any questions in the room? I will also check online. I don't see any. Do you want to bring Clinton into the stream and see if they have questions? Anyone at Clinton have questions?
Yes, we have a question. Give me 1 second.
Does he have an idea about how it affected pop culture? Like, for example, I read something that the movie by John Ford, Searchers, was brought a lot of this, and so it was affected by Brown versus Ford. So, what effect did it have on popular culture?
Professor Washburn, can you address the effect of the Brown decision on pop culture?
Oh, so the effect of the Brown decision. The question was the effect of the Brown decision on pop culture. And really, I think I don't know that I'm quite able to do that very well. I mean, it was a big deal across the nation, right? It was one of those situations where I think, heavily publicized, Much of the country didn't like it, but really, it was the first big case that said, the segregation in and of itself is bad. And I think in that kind of thing, Brown became the rallying cry for everything that came after. Right? There's a reason that we have a national historical monument to Brown in Topeka. There's a reason that whenever you talk about segregation, you don't talk about the North Carolina case much, or the South Carolina case, or the Delaware case. What gets talked about is Brown, and what gets talked about is the little schoolgirl who wanted to go to the school near her home. And I think that's the image of Brown that we get burned into our history going forward.
Do you have another question, Brian?
No, that was fantastic, Professor Washburn. That was incredibly thorough. Thank you for that very great explanation of Brown.
Okay, we do have a question in the room.
How typical is it for the Supreme Court to issue, because we know there's a Brown 2, Brown 3, how typical is that for them to come back to a case and keep at it like they had to do with Brown?
Yeah, it's not very typical, is I guess what you would say. With Brown, right? Yeah, we had the Brown 2 because the justices wanted such a united front in Brown that they kind of left the question of remedy to a little bit later. And then, of course, Brown 3, for those of you who don't know that, because it's not well known, was filed in the late 70s. And I should mention by 3 Washburn law professors, all of whom I had. But those 3 had, and it was part of this idea that the Topeka had de facto segregated itself in the way that it was allocating monies and things, and we're unequal there. So it's not very often. You do see it every so often, especially the times that you see it more are when the court has a case and then they order some kind of relief and they send it down to the lower courts to talk about it, about what might happen, and then it comes back. Brown is weird in that respect, in that it didn't come back. It's just they decided something and put off the rest for a little bit later.
Okay, I do have a question. I'm not sure if you'll be able to answer it, but a lot of school districts across the country, one of the ways that they try to continue to combat segregation is with like magnet schools, and also with the redistribution of property taxes.
Yes.
Excuse me. We're starting to see though more, or we have seen, people are pushing back against that, even suing school districts about that redistribution of property taxes, wanting it to stay right in their local area, not wanting like magnet programs that bring bus kids from all across the cities and things like that. Are we seeing more lawsuits about that? I mean, I hear about it, but I don't know that there have been more lawsuits. And then how do those lawsuits look in the face of Brown?
Right. So I don't know that we're seeing more lawsuits. I think, along with a lot of things that happen these days, when we sit here, it's that every lawsuit gets publicized, right? I mean, if you were to take a look back, right after Brown, the kinds of things that happened, I guess one of the interesting things that you bring up here, when you start thinking about, we're seeing lawsuits, we're seeing is that the many school districts had some problems with Brown. In fact, the and I'm trying to remember which. Oh, so for the Virginia case that was Brown, right? The Prince Edward County. Prince Edward County reacted to Brown, saying you had to desegregate your schools. Prince Edward County reacted to Brown by completely defunding all of their public schools for 7 years. We don't see that kind of stuff today, right? But I think the important thing to think about Brown and really equal protection and all of the federal laws that feed into that, right? They're less about redistribution of property tax, although it's probably a good policy situation. But they're less about that. The point of Brown is to end segregation by law, right? To say, no, it is not right for the law to demand segregation. So I don't know that we're seeing more lawsuits. I just think, again, we know every lawsuit that gets filed about that, right? That makes the news and we access them.
Hi, I'm interested in how is charter schools affecting, or how will Brown affect charter schools? Because I was listening to a debate Congress about a week or so ago, and one of the congressmen said that in the state of Texas, 95% of the kids that got the vouchers for charter schools were your upper middle class, wealthy kids. And he named some other states too, but I do remember Texas. How will that affect Brown? Because Brown was not about rich people. Brown was about race.
Yeah. And I think if what we're talking about are the private school vouchers, so which I think is probably not great policy overall. I think because I think it's damaging to public schools. Because I think what you're going to see is segregation again. Although I'm not sure it's going to be racial segregation so much as socioeconomical segregation. To the extent so, and in that as we've learned, that's just not treated the same way under the Equal Protection Clause. That is, a distinction based on race gets strict scrutiny and almost everything gets struck down. A distinction based on money gets rational basis and is almost always upheld. And so I think that's a real problem if we talk about socioeconomical segregation, especially if the vouchers starve the public schools of what would otherwise be their funding. And I think that is a big problem. I guess one of the things is, but I don't think the US Constitution speaks to it as much. Instead, you end up with state constitutions like Kansas, for one of them, right? Kansas has a provision in the state constitution that says you have to fund your school districts. And so generally speaking, in those situations, I think that gets lessened.
So I want to throw a dreaded counterfactual question out at you.
I love counterfactuals.
What
I can think of many
happens?
things
What happens to Brown v. Board if Ike does not step in at Little Rock?
That is a very good question, because I think we eventually get there, but I think it's a lot longer road, right? Because if you saw basically what is the massive organized resistance in the face of Brown. But without Eisenhower sending in the troops in Little Rock, we maybe don't get Cooper versus Aaron, which is the case that pretty much, you know, I always say that that's the one where the U.S. Supreme Court told all of the states, stop it. Right? No, I think that in and of itself was a courageous thing to do and be the right thing to do. I mean, again, would we have gotten where we are now without it? Possibly, but it would have been longer and it would have been uglier. And I think, you know, there's a lot the Eisenhower administration can say they did really right, and that I think is one of them. One of the big ones.
All right, I'll check one more time with Clinton just to make sure you don't have any questions.
All right, thank you so much. I appreciate
All
it.
right, thank you, Professor Jackson. Thank you, everyone, for watching. Once again, we are ending this stream, and our next program is at 1:30. Please start getting ready to log on at about 1:25 so that we can start right on time. I'm really looking forward to this one. I'll have a great break.